need to qualify more definition and more phrases in terms of the references to the impact of the condition of the witness ability to testify. And it is our concern, Chair, that in this current context, it's practically reality that respondents in a domestic situation often use the system against complaints, either by obtaining protection orders against the true affected victims and or making counter applications for protection orders of their own against the true victims. We are also looking at the fact that perhaps, yes, the police officers will have to receive significant better training and guidance on how to exercise their discretion on issues of arrest as set out in the Domestic Violence Act. Further, Chair, we are also looking at, we have made a submission on Clause 5 on the cancellation of bail. The Commission fully supports Clause 5 of the bill, which will hopefully discourage accused persons from making threats towards or interfering with victims and witnesses or being dishonest with the court regarding existing or pending protection orders. We are further saying that the use of technology to give evidence is much more welcomed. We know that the use of CCTV and other electronic technologies to facilitate the hearing of evidence in court, even by witness outside the Republic of South Africa, will actually aid in making sure that we bring justice to court, and the geography does not stand in the way of crucial testimony. We are further saying that the use of technology Clause 7, Chair, on the conditions that make an evidence difficult. The Commission welcomes Clause 7, and we recognize alternative forms of expression by witness that are not able to speak their evidence in court. This is in addition and in line with the Constitution's rights of persons with disabilities and other medically affected people, in a way that sometimes people would have speaking or articulation difficulties, and these will actually aid in making sure that interpretations and people are able to put their cases forward. In terms of Section 9 on victims' rights, to be presented at the parole hearing, the Commission fully supports Clause 9, and we also further assist in creating a more victim-centered criminal justice system, which I think will ensure that the victims will be made aware of their right, not only to be present, but also participate in a parole proceedings and have their voice heard.
You're left with 6 minutes.
Thank you, Chair. On the Clause 11 and 14, on the expansion of scheduled offences, we fully support this clause, these two clauses, and we are actually saying as the Commission that they are welcomed because there is inclusion of dangerous forms of assault to the following schedules, which is Schedule 1 to the Criminal Prosecuting Act Act of 1977, and there are Part 2 of Schedule 2 to the Criminal Procedures Act, Schedule 7 to the Criminal Procedures Act, and Schedule 8 to the Criminal Procedures Act. So Clause 15 and 17 on minimum sentences, the Commission also welcomes the fact that the crimes involving sexual and gender-based violence are heinous and perpetrators must be punished severely. However, the Commission strongly feels and have reservations about supporting the further increase of a minimum sentence in South Africa based on the research that actually says that, yes, we can actually increase the minimum sentences, but in many cases, this doesn't work. We have actually seen that high minimum sentences have been put in place for offenders, and this does not reduce the fact that, or it doesn't deter the perpetrators from actually committing these heinous crimes. However, the criminal case law in South Africa clearly illustrates that our minimum sentence framework for sexual offenses has not only yielded either of the benefits, but the sentencing itself has always been inconsistent, and this is something that we have seen. So the minimum sentences in sexual offenses case are regularly treated as a maximum sentence instead of, and often departed from by courts. Last but not least on this one, Chair, I think basically what we are saying that whilst the minimum sentences do not deter or reduce sexual offenses, in our eager attempts to deter and reduce sexual offenses, we assume that perpetrators would be scared off by the prospects of longer prison sentence, and over time we would see of perpetrators in numbers committing the same crimes. So our recommendation on this one, Chair, is that this should actually be looked at and in the bill, whether we are increasing the minimum sentence or we are making sure that the bill speaks specifically to this particular one, Chair. And in terms of the existing laws, I think broadly the Commission for Gender Equality actually welcomes the efficacy and the strategy that has been employed in terms of contributing to all the SGBVF laws and legislations and the bills that are coming. But we are also saying that when it comes to survivors and their families, we need to make sure that services are provided and they should be family-centered in response to gender-based violence. On the last one, Chairperson, last presentation on the Domestic Violence Bill, basically the Commission for Gender Equality Act has also made a submission, particularly on the bill itself, to the Portfolio Committee, and the submission on the Domestic Violence Act bill, sorry, Chair, basically looks at the following areas that we felt that they should actually be looked at closely by towards moving to the Act. The proposed amendments brings to the bill in terms of our Protection from Harassment Act, the issue of ISPS, which is the online forms of harassment. The CGE is specifically pleased by the introduction of the centralized recording of all protection orders, application and orders. So we are pleased with this proposed amendment. This was long overdue, Honorable Chair and members, and it will revolutionize South Africa's ability to better understand, prevent, and combat domestic violence in our country. The Commission for Gender Equality also notes the progressive use of technology in respect of services of documents. And however, we think that the bill will definitely allow for electronic use of services in certain instances. And without any further doubt, this will actually bring quite a lot of measures which will actually reduce the administrative burden on the side of the police as well as on the side of the courts. So it's important, Chair, to note that this particular move towards harm as opposed to imminent harm throughout the bill, and the move away from dangerous weapon to the use of weapon instead, will assist in the multiple or in the multitude of cases where police officers themselves are perpetrators of violence or alleged perpetrators of violence. Honorable Chair, in terms of the another important milestone, we are encouraged by the further introduction of the state's expenses. This was in the legal aid. This was an initiative in consultation with the Legal Aid South Africa to assist children with applications for protection orders. And we also note that the state's assistance for complaints who cannot afford the fees of services of domestic violence are in particularly here are addressed. Clause 3 on mandatory reporting on domestic violence. The Commission unfortunately does not support the introduction of a generalized mandatory reporting duty on any person in the context of domestic violence. However, the Commission submits and proposes that there should only be a legal duty to report a reasonable belief or suspicion that an act of domestic violence has been committed against a child. The submission is congruent with existing legislations for the maximum protection of children who are especially seen as vulnerable groups in this regard. In terms of...
your time is up.
Thank you very much, Chair. I will skip a few slides where we are actually in line and in agreement with the bill. I think clause 5, clause 6, we are in agreement, Chair, and we are concerned. However, when it comes to application for protection orders in clause 6, and our concern is that perhaps lay persons may not be aware of the arrangements in respect of after hours availability of courts. And we are also concerned that availability of courts and after hours might actually impact on people who come from far-fetched areas, rural areas, who may not actually be able to access after hours kind of courts, Chairperson. And in terms of the final comment, Chair, we just want to really thank the Portfolio Committee, and we hope that the submissions broadly made by the Commission will, however, find expression. And we are saying that we have concern about the mandatory reporting suggested by the bill, and the CGE would like to express its sincere gratitude for the opportunity to make the submissions to the Portfolio Committee. Thank you very much, Chair.
Thank you very much. I've noted the following members who would want to ask questions: Honorable Horn, Honorable Mufokeng, in that order. Honorable Mufokeng, Honorable Horn. Let's start with Honorable Horn.
Thank you, Chairperson, and thank you to the CGE for the presentation. Chair, I wanted to address the support of the CGE for the recommendations around no bail. And I want to ask the CGE, given the fact that they are one of our human rights bodies, albeit with a focus on attaining a gender equality, they obviously, as a Chapter 9 human rights body, hopefully would have considered before expressing their support for that proposal, whether such a proposal and an absolute prohibition on giving, legislative prohibition on giving those arrested in respect of the specific gender-based crimes they are accused of, bail under any circumstances, whether the rights afforded to people in terms of our Bill of Rights to a fair trial, and specifically the presumption of innocence, will not be undermined by such a legislative framework. So if we could get their comments in respect of the no bail proposal firstly, and then secondly, Chair, I think we take note of their opposition against the general reporting obligation, but it would be helpful if they could unpack their reasoning behind this a bit further. I don't know whether it's because has been a long day, but I struggle to find the rationale behind their opposition in the presentation. Thank you.
Thank you, Honorable Mufokeng.
Thank you very much, Chairperson, and thanks for the presentation from CGE. Chair, I want to start with a question on the Commission. Have been very active, as we know, and I always said that we are the custodian of the Domestic Violence Act of 1998. But there's one thing that I wanted clarity, and I don't hear anything coming from all the presenters about. On the domestic violence, we know that what is it? It's physical abuse, sexual abuse, emotional, all those things are mentioned, but nothing is said about the economic abuse. And if you are a commission for gender equality, then you find that all the time we're talking about the abusers that are struggling, they have to move out of the house. If it's about the protection order, you find that the husband, if he's a well-off or a spouse or whatever, they will come with attorneys and pay a lot of money. But we don't talk about this loss of resources, medical care, and relocation of a person. And I don't hear you saying anything about this, because this is part of those things that are really a challenge in whatever is happening in the life of an abuser, especially women and children. The second part will be on the issue. I agree with you on training of South African police services, prosecutors, and magistrates. But now I want to know that, will you agree with me that it's high time that we need people that are specializing? If you are a teacher like you are, for an educator, I know by profession, you would want to specialize in maths or biology and all that. Why don't we go that way? People will be trained and then they must go and specialize, so that GBV must be a center, and as we call it, a pandemic, people must be able to centralize their work and everything there. But the last part is on what you are saying about the centralized orders. I want to understand why, because we know that there's been this issue of saying protection orders are given left and right. You find that one man has been with many women, but all of them have been abused. We have serial abusers. But once those orders are given, a person moves to another woman, does that same thing. Are you saying that they should be centralized in order that they must be captured to be known and be seen by public from province to province, and see that here Mufokeng is an abuser, or Maseko is an abuser, an example of that? Can you maybe clarify me on that? What is that for? Thank you, Chair, and thank you.
Thank you very much. Over to you, CG. CGE. Have we lost them? Bonani, can you check?
Honorable Chair, apologies again. I think we're experiencing some technical glitches this side, connectivity issues. I might have not got all the questions, but I think I just got the last part of the questions, Chair, and I will allow my colleague, Mr. Dennis Matotoka, to respond to the first question, Chair, or first set of questions that I did not pick up. I think the questions by Honorable Mufokeng on economic abuse, clarity on economic abuse, an area that hasn't been addressed by any of the presenters. I would agree fully with Honorable Member Mufokeng on the fact that I think it's high time that we need to look at the economic aspect in terms of empowering the victims or women in general in South Africa, who in most instances are the victims of sexual and gender-based violence. And I fully agree with her, Honorable Chair, in terms of saying that in most instances, they are the ones that are asked or made to move out of the houses together with their children, if they are lucky, to places of shelter. And I think in most instances, and what we are looking at now, Honorable Chair, is perhaps a situation where we can arrange for the perpetrator to be taken out of the house and leave the woman and the children inside the house to actually be able to stay comfortably in the house, but also take the perpetrator into a place of safety, but not only just take the person there, but make sure that there is some kind of counseling, there is some kinds of interventions that are put in place in terms of making sure that we deal with the perpetrator himself or herself. Chairperson, during the lockdown period, there were two centers that were opened for perpetrators in around Gauteng, where perpetrators were taken out of the houses, not out of their own will. to be in the places of houses and shelters. But I think more broadly, we are now devising some programs that are looking at gender equality, but also women empowerment, where women should actually be empowered and should be able to stand alone and be self-sufficient in terms of making sure that they also contribute to the broader economy of the country, Chairperson, so that there is no reliance onto the partner or to the perpetrator in terms of income or money that should actually be getting or into the house, and or they should also be empowered to be able to put bread on the table, Chair. I think these are some of the reasons and the drivers of gender-based violence and domestic violence that we have seen over time. So I think this is one area that we all need to venture on, both as government, civil society organizations, but also Chapter 9 institutions will actually be monitoring these particular areas that will ensure economic empowerment in general, Chair. Part 2, in terms of training of SAPs, but also specialization areas. Chairperson, this is one area that we have actually engaged the South African Police Services, and we have engaged not only the 9 commissioners in 9 provinces, but also looked at the training aspect, whether we can contribute to the training of the South African police in terms of specialization, so that there are South African police services who come out of the academy with a specialized area of training that will focus solely on addressing issues of domestic violence and gender-based violence. So this is one particular area that we are currently negotiating. We will be looking at modules, and we will be looking at areas of specialization, so that in each police station and in each areas, there are people that are specialized to actually look at these particular areas. And Honorable Chair, I think Honorable Mufokeng is quite right. GBV is the second pandemic. It needs resources, not only in financial terms, but also in human resources terms. People that have specialized, that can actually intervene, and with particular areas that they know better and know how to actually intervene in those areas. I did not get the last question, Chair, but I think it was around centralized orders. I would request Dennis Matotoka to respond to question 1 and to the last question, Chair. Thank you.
Thank you very much.
Chairperson, thank you so much for the opportunity. With regard to the first question around the presumption of innocence in as far as bail is concerned, the CGEs are alive to the Section 35 of the Constitution that really provides the rights of the accused persons and to be presumed innocent until proven guilty. And that is a rule of law that our office really supports in understanding that there must be processes that must be taken to ensure that elements of crimes are proven beyond reasonable doubt. Now, the issue of bail before the Commission is we need more strict measures before bail is granted by the courts. What we are observing on the ground, or what we are observing with the courts the cases that we are monitoring before the courts, is that the investigating officers, for example, they don't verify the addresses of the perpetrators. They don't ascertain whether if the perpetrators are released will result in the interference of witnesses, or by extension, even the killing of victims themselves or survivors themselves. So what we've been observing in our monitoring process is that bail's conditions are not that strict. It would seem more often than not, reliance is placed on the versions of the investigating officers. And that more often than not, it places victims and survivors at a greater risk. And we have seen now administration of justice being undermined because of that. So our view is that we really need strict bail conditions where we will ensure that it is not just the discretion of the IO, the investigating officer, that they have verified the address of the accused person, for example, or they know that the survivor is in a safe place. There needs to be much stricter requirements that are met to ensure that the bail is not as easy granted by the court as it is in this situation. Because what it then does is that it creates an impression from the communities that the justice system is not responding to the core issues at hand. And that results again in most committee members now taking the laws into their own hands. Whilst we do not support that, and we do not say people must take the law into their hands, but we are saying the justice system must equally respond to the core issues that the communities are raising. And that is, we seem to have measures that are not strict enough when it comes to bail conditions. Thank you, Chairperson.
Thank you very much. I think we were also asked to respond to the last question.
Chairperson, my apologies. I may have skipped I missed the last question.
I can do the Chair.
Yes, Honorable Mfuke.
It was about centralized orders. You were saying that you are looking at centralized orders, and I'm saying, what is the reason for that? And I was saying that we have noted that we have serial abusers. Is it because you want every province to see if an order has been given, or it's for what?
Chairperson, thank you for making it clearer. It is important, Chairperson, that we have a single centralized system in South Africa, where we would know that we don't have to rely, for example, if the accused is appearing in Northwest, if I may give an example, in the regional court, there must be a system where it will be easily traced that this person has a record or there is an order that is granted by this person. Because what we have seen in terms of basic administration, even in terms of files, in terms of orders, we find that people who have records, people who have orders granted against them, they continue to enjoy the benefits of a justice system, primarily because we are unable to have a technological system that is able to link the accused person or the person who has an order granted against them to another offense or another order that is granted in other provinces. In our monitoring of courts, Chairperson and honorable members, we have found that the administration of files by the courts, we have monitored the sexual offenses court, we've monitored the domestic violence courts. More often than not, we even find that the physical files, some are placed in the corridors of the courts, and some files are missing, the contents are missing. In such instances, we are unable to link the accused or the persons who are before the courts to other crimes in other regions. So a centralized system has more benefits than one. It's easy accessible, and to ensure that justice is effective to the benefit of those who seek justice. Thank you, Chairperson.
Thank you very much. Can we move to the next one? Thank you to the Commission for Gender Equality. Can we move to the last presentation? I'm not sure whether the last presenters, in fact, let me check this. The Action 8, they had problems of connection. I'm not sure whether they have been able to connect. Can they indicate? Mr. Ngumalo, were you able to connect? Seemingly, we don't have representatives from Action 8. Anyone other than Mr. Ngumalo who is present?
Good day, Chair. Good evening, Chair.
Yes, Mr. Mtonjeni.
Yes, Chair. Bonani has just informed me that he was on the phone with them. They say they have network problems. So for now, they won't be able to connect where they are, Chair. We'll engage with them maybe and find if it's possible some other time, Chair. But currently, they are experiencing extremely difficulties with network.
Okay. We will check them tomorrow or Friday if we can squeeze them. So which will bring us to the end of the public hearings for today. The next public hearings would be tomorrow. It will be 6 o'clock. Is that correct, Mr. Mtonjeni?
Yes, Chair.
It will be 6 o'clock. Can you read out the organizations that would be presenting tomorrow, including the Action 8?
I'm just trying to get to the document, Chair. A second, sorry.
Okay. And in the meantime, Bonani, what was your resolution with the EFF? Are they coming tomorrow or Friday?
Sorry, Chair. Bonani as well is been kicked out by the system chairperson. Currently, he's out of the meeting, but I will talk to him immediately after the meeting, Chair, and find out, because he was on the phone with them immediately after they made the proposal that they want to make presentations.
Okay.
The other presenters is Prof. Ann Skeleton, and it's the South African Catholic Bishop Conference. It's the Women's Legal Center. It's Embrace Project, Wise for Africa.
CR, can you please slow down?
Oh, okay, sorry. It's South African Catholic Bishops Conference. It's the Women's Legal Center, Embrace Project, Wise for Africa, the Western Cape Government, and Voice It in Action. We will send out this list during the course of the day tomorrow, Chair, or in this evening, Chair. After I've engaged with Bonani in regards to the EFF and maybe Action 8 as well.
So the list that you are reading, is it for tomorrow or does it cover tomorrow and Friday?
The one I've read, Chair, it covers tomorrow and Friday, Chairperson. From tomorrow to Friday, with the exclusion of the EFF, of course.
Let's focus on tomorrow for now. Let's focus on those who are coming tomorrow.
Can I then speak to Bonani and find out the arrangement, and then we make the arrangement for the Action 8, then we finalize those, because they were before the others. And then we'll finalize and consult you and send out.
Yes, if that can be sent to members tonight, so that we must know how many, which organizations are we meeting tomorrow. The reason I'm insisting on knowing is so that members can be in a position to read the presentations that would be relevant for each day, and not to be overwhelmed by reading all the documents when they will not, the people would not be appearing on that particular day. So we need to focus for tonight in reading the documents for tomorrow. So it will be important that we know which organizations are coming tomorrow.
Noted, Chairperson. It will be sent out tonight. Thank you.
Thank you very much, honorable members, and thank you for your hard work, and thank you to all the organizations that made presentation, and everybody who has been listening. And we have also taken note of the comments that you have been making on the chat and the suggestions, and some of them would be captured in our discussions, in our deliberations. Thank you very much. We'll see each other tomorrow.
Thank you, Chair.
Thank you, Chair.
Thank you. Thank you.
No, yeah, no.
Thank you, Chair.
Thank you very much. Thank you very much.